and the Law and Technology Initiative. Let me tell you a little bit about the background of the class. So first of all, I just wanted to make sure too and encourage you, please, to join a discussion on social media. The hashtag for this event is NLawCS. The Twitter handle that we use is NLawBizTech, and we have a student, Mona Kalantar, who's going to be doing some tweeting and using that hashtag, and we hope that others will join in the discussion online, whether it's on Twitter, Facebook, LinkedIn, about this event. Also, just some video conference etiquette. If you can please keep your audio muted, and student and panelists, also please keep your audio muted and unmute only when you're speaking. And we do want to encourage people to use video though. I mean, that's great to be able to see each other and really be able to build community and feel like we are kind of in Thorne Auditorium where we were last year in one community together. So this is a picture from the Innovation Lab last year. We ran this class in the Thorne Auditorium so we could have a nice big space where we could have everyone working together. Last year, we had 34 students. We had 36 students this year. It's computer science students, including Master of Science and AI students, law students from our JD and LLM program, and also law students in our Master of Science in Law program. We have 7 projects this year with a great group of project partners. Actuate Law and Allstate, our student team worked with them on data subject privacy law requests, so building better privacy compliance. We worked on a project with our Bluhm Legal Clinic, Eviction Court, Navigator. You're going to see a demo about that. We worked with the Cook County State's Attorney's Office, Orders for Protection for Domestic Violence, a project with the Honigman law firm on health law, innovating compliance with Stark Law. We worked on a project with the International Association of Contract and Commercial Management and Simplifier, distance measurements for contract revisions. We worked with the Orrick law firm and specifically their Supreme Court and Appellate group on case information extraction and flashcard generation project. And then we worked with Thomson Reuters and Judge Wilfredo Martinez in Florida on a human trafficking judicial case management project. And just a quick important point about this, these were truly collaborations with our outside partners. They didn't just toss us a problem and say, go to it. The student teams, these interdisciplinary teams have been working with the project partners each step of the way for the class. This is part of our Law and Technology Initiative, and there's a history of interdisciplinary collaboration here at Northwestern across campus. This is part of other academic events that we're doing. Matter of fact, just about a little over a month ago, we had an event where computer science and law faculty gave talks about law and technology topics and the research they're doing. And we have 20 faculty come out and give talks on these topics. So there's real deep interest in this interdisciplinary collaboration here at Northwestern University. And Kris, if you could just take a second to talk a little bit about the CS+X program and some of the stuff that you're doing here, engaged with here at Northwestern around law and technology.
Absolutely. Again, thanks everybody for being here today. This is super exciting. I mean, in the midst of all this, it's kind of strangely enough, it's kind of fun to be able to do something in a way that's very different than the way we'd normally do it. I'm one of the point people on our initiative in CS+X, which is really the notion, it's a university-wide notion that computation is going to have an impact on every single field that exists. And that in order for that impact to be done right, to be done correctly, to be done to the benefit of both the field and, in fact, the people who that field serves, we need to make sure that the people who are in that field are the drivers. So what CS+X is really all about is creating these partnerships, this relationship between fields like the law, journalism, medicine, business, and computer science that helps us, steer the ship in the right way and get the right kind of impact. The exciting thing about this class with regard to CS+X is really kind of straightforward, and that is, we don't know exactly what the impact of computation on the law is going to be. We really don't know yet. What we do know is that the way we find out is we let people work on different kinds of projects and explore the space together. That is to say, students in the law and students in computer science working hand in hand to go on an exploration of the world of the possible. And this class is really all about that. And I've got to say that this is my third year working in this class, and every year it gets better, and every year it gets more interesting, and every year it gets more innovative, with the students telling us more and more and more about what can be done, what's possible, and help to craft the framework that is the future of law and technology. And so I'm thrilled you're here, and I hope that you take away not that, oh, there's a whole bunch of finished technologies right in front of you, but in fact, what you take away is that these are students who are blazing trails, and they are what's going on in that massive jungle that is the future of law and technology. So with that, back to you, Dan.
Thanks, Kris. All right, so let's, we're gonna move forward, and let's start by introducing our expert panelists. And I'd like to just give each of our panelists just a minute to tell us a little bit about them, what they do, and why they wanted to be a part of this program. But Colin, could you please kick things off for us?
Fantastic. Hello, everyone. Thank you, Dan, for inviting me for this exciting session. Khalid Al-Kofahi, and I head research at Thomson Reuters, as well as the Center for AI and Cognitive Computing. We are a team of scientists, engineers, and designers with a very simple mission: to work with our business partners to identify and realize product opportunities that are enabled by AI and machine learning. And I have been sort of in the machine learning NLP space for, excuse me, at Thomson Reuters for over 25 years. Started my career working for the legal business and been working at the intersection of law and technology for all of that time. And I am very excited about meetings like this. You know, back then when we started doing computer science and AI and machine learning and law, we were essentially at the margins. And now I think we are at the center of the business as well as the practice of law. And seeing sessions like this that bring scientists and lawyers and engineers together is extremely exciting for me, and looking forward to the session.
Thank you very much, Colin. Jason Barnwell, can you please take a minute to introduce yourself? I think I see.
And I was muted, so
okay.
I'm great with technology. Thank you so much for having me today. I work for Microsoft. I lead our modern legal team. And in a nutshell, my focus is on figuring out how we're going to make digital transformation work for our entire department. We have massive challenges in front of us as our business accelerates and scales. And so the reason I'm here today and I'm interested in what is to be shared is we're always on the lookout for opportunities to partner and work with others and build on the things that we find in industry, at schools, really from any vector. And so I'm just excited to see the innovation that's going to be brought forth today.
Great. Thank you, Jason. Farah Pepper. Farah, can you take a minute to tell us about yourself?
Sure. So other than the fact that I'm rocking this very stylish headset here, my origin story is I started out as a straight up litigator at a big law firm in New York, Gibson Dunn. Thought I was going to do litigation, but then got really, really interested in what I thought was the sexy area of e-discovery, which is the confluence of technology and law. So got very focused on that, started my firm's e-discovery practice group, and then made the leap to in-house. My first in-house gig was at GE, building their discovery program and being their first global discovery council. So I've always been interested at that intersection of people, process, technology, and I guess some of my former litigator friends think I'm a weirdo because I find that so interesting. But here we are in my current gig, which is Chief Legal Innovation Counsel at Marsh & McLennan. Marsh & McLennan, if you're not familiar, is a New York headquartered global company. It's got a corporate hub and different businesses in health, wealth, and risk, things like insurance broking, reinsurance consultant, and so on. So my role, which is a new one, is focused on how do we bring all of the exciting innovations happening out there in the world to the legal and compliance teams, and just basically work smarter, better, and not be left behind. So I'm thrilled to be here today because I'm looking for my daily dose of inspiration and to see all the wonderful ideas that everyone's had and potentially leverage them going forward in our own practice.
Outstanding. All right, thank you very much, Farah. And Luke Tannen from Chicago Innovation, the Executive Director of Chicago Innovation, will be joining us, but he has a conflict in his schedule, so he won't be here till about 5, but he'll be joining us then, and we can hear a little bit about him then. So we're going to jump into the demos here real soon, and just so people understand the format. So each team has 8 minutes to demo the technology they've created. They're going to tell us a little bit about the problem and their approach, but they're demoing real technology solutions. These are real working applications. This wasn't just a design jam. And then we are going to have 7 minutes for questions and answer with our panel of experts for each team. So the agenda, this is the order of the teams they're going to be presenting. We're going to have the Honigman team go first, the Orrick team after that, the Cook County State's Attorney's Office team, the Bluhm Legal Clinic team, the team that worked with Thomson Reuters Labs and Judge Martinez, the Simplifier IACCM team, and then closing with the Actuate Law and Allstate team. And then we're going to have time at the very end for our panel of experts to give us some closing remarks about what they saw and the opportunities in this space and so on. So again, join the discussion, please, on social media. NLawCS is the hashtag. You can tag NLawBizTech if you like, but we'll pick it up just with the hashtag. But with that, I'm going to stop sharing, and I'm going to turn things over to the Honigman team to go ahead and display their slide deck and go ahead and take it away.
Cool. So hello, everyone. So we've been working with Honigman to create a tool for Stark Law liability review. And our interdisciplinary team consists of 3 students in the McCormick School of Engineering studying computer science and AI, and 3 students in the law school working together with Andrea Lee and Drew Sanders from Honigman. So the Stark Law prohibits physicians from referring patients to any health service within which they receive like a direct or indirect like financial benefit. So it assures patients and it assures taxpayers that there's really no fraud and that the patients are receiving the proper treatment and not overpaying. So for example, Dr. Smith here is an owner of a primary care practice, and he wants to refer elderly patients who, when medically appropriate, need in-home health services. There is a home health agency called Home Health that provides this care, and Dr. Smith uses this service, and through that he receives cash benefits and also stock options for being on the board because of his amount of referrals he's referring them. However, he doesn't really feel right about receiving such generous compensation, but he continues to refer these patients, and he really needs to know whether there is a Stark Law violation. So what's wrong with the current solution is, first, the physician doesn't really know whether the Stark Law applies, and they must consult a lawyer if they suspect they're in violation. The Stark Law is a strict liability law, so even if they're unaware, they can still be penalized. And that penalty is $15,000 per claim. So going back to Dr. Smith, if he makes 100 inappropriate claims in just 1 year, those penalties would be at least $1.5 million, without considering other penalties under similar statutes or attorney's fees and etc. And really, unfortunately, hiring a lawyer is not easy, and it's not easy to determine whether the Stark Law applies to any given referral, and it's expensive if that lawyer doesn't have any meaningful experience. So that's where our tool comes in. Our tool is here to help that physician gain an insight into whether this law applies and then streamline the data intake process without first having to consult a lawyer. It enables a more efficient conversation between the physician and a member at the Honigman team, who can then analyze that specific arrangement and give Dr. Smith his legal advice that he needs to know concerning the Stark Law.
Right. So the way this tool is accessed is basically just making it available on the Honigman website or any other law firm. And this is a way for the lawyer, just as Josh mentioned, to touch base sort of with a virtual review tool without having to commit any money or time for actual legal review. So we go into this tool, we have some short description of what the Stark Law is, and without further ado, we can just jump in immediately and show you how fast and easy it is to just give up a few pieces of information from Dr. Smith's life that already tell us some details about whether or not he's in violation. So he goes for a few simple steps of just identifying himself, where he works, whether or not he's self-employed or not, and we're faced with the obvious question, perhaps, that whether or not he's referring patients to another entity. In this case, Dr. Smith is unsure, so he answers maybe, and we go into this very central part of the application, which is just these very responsive sort of question-answer pairs where we're trying to find out what kind of referrals Dr. Smith makes and whether or not there's any kind of violation. So we know he's making referrals to home health services. Like mentioned before, he's the one making those referrals, and we know it's for physical therapy for the elderly that he cares about. If there's any point where he's not sure of the wording or perhaps the language of some of these sections, we always offer some additional places to find out more information to get more knowledge about this. Continuing, as Dr. Smith, we know that our patients are covered by Medicare and probably Medicaid. And like mentioned before, home health services starting to offer us some influence over the company through stock options and offering us monetary benefits through cash payments. So in our case, this is only one referral, but there's space to make additional sort of declarations about other referrals. And when we walk through these simple steps, we basically have this simple report generated for us, which already tells us there is a high chance that we are in violation of the Stark Law. And you can go over some justification as to why that is the case, as well as a risk assessment portion, which takes those questions and gives you explanations based on your answers and on what information you gave us, as well as additional details concerning exceptions and, well, essentially sort of an invitation to consult a lawyer, just because there is so much more than that could be inferred from the facts that Dr. Smith provided. But what's most valuable about this, in our opinion, is the fact that by generating a report, we create this structured and streamlined version or streamlined representation of Dr. Smith's situation, which is easy not just for him to understand whether or not he's in violation. It's also easy for the lawyer, who might not be experienced with Stark Law review, to easily analyze those typical pain points that he's going to be looking at many times throughout his career. So as to what we want to do with this application, if we have time to expand it, is to essentially just add more questions, add more lines of inquiry. We've been discussing maybe giving more contract review options for uploading documents and looking over whether or not there's some exceptions that apply. So really the field is very much open, and this is just a small portion of how much you can generate with very little information taken from your client. So this is basically clear state, and we'll be happy to take your questions now.
Great. Thank you, Honigman team. All right, does our panel of experts have some questions for this team?
So this is Farah. I've got a question. I think it's looking awesome. I appreciate whenever there's visuals, especially when it's sort of thermometer style. I like that. But I have a question way back on that first entry screen. I noticed when you were typing in some words, you actually had a typo. You know, I think instead of elder law, I think you wrote elderly law or something that wasn't a word. So I was curious, did you build in capabilities to kind of have fuzzy search or things that would capture things in case people don't even know what it is they're trying to say?
So that was just me being a little nervous. When it comes to generating reports on this specific sort of application, the specialty location employer is more of a showcase of what essentially we can collect as information. We do have some checks installed for names and last names and that sort of thing, just as a, let's say, as a proof of concept. But I think this is the kind of thing you can always add once you're developing this for scale. So not right now, but yeah, sure, it's always available to just tack on these additional checks. It's very modular, so each page, each question is sort of its own thing. You can remove them, you can add more. You can always hide certain parts of it behind a paywall if that's perhaps your wish as a service provider. So really, this is just a bare bones skeleton we can walk through.
Well, and I would say you didn't have to tell us that you were nervous. You could have said, yes, I was illustrating that you can capture all sorts of forms of stemming. So thank you for the explanation.
Thank you.
Hey, this is Khalid. Thank you. It looks very good, actually. I like it. Good job. A quick question. Is the idea that at the end of the day, once this is ready, is the idea that there is always going to be sort of a lawyer in the loop, even if the risk is very low, the risk indicator is very low, or is there a potential for, if the risk is very, very low, go ahead and, does that constitute a legal advice? Just some, if you can elaborate on that, please.
So this was an issue that we've been discussing all along the design process. I think Josh or Alex, if you're here, you can also chime in. We've basically been figuring out the situation of a bad faith actor, someone who uses a tool like this in a scenario where it's completely autonomous, and he could actually use the tool to sort of game the system and claim that he's gone through these steps and the way he's done it, he should be safe, right? Because the tool did not classify him as at risk at all. So we've knowingly sort of reduced the amount of information being thrown back at the user just to make sure that he understands that as soon as he enters any kind of information that he suspects something, he may essentially be at risk. So going forward, it would be great if it were autonomous, but until you reach that 100% sort of result, there's always some risk, and whoever provides the service is the one who's being liable for providing bad advice. That's why we also had disclaimers at the end, which basically sort of void us from any, void Honigman or us as service providers from any kind of responsibility.
And a follow-up question, if I may. Can I do a follow-up question there?
Absolutely.
Yeah. So from a technology perspective, what was sort of the biggest technology challenge that you guys had to deal with?
I would say this project was, in terms of technology, it's quite simple. It's mostly front-end web development. So perhaps working in some of the logic, trying to stick just to a single sort of, just building it as a website. Perhaps you can always expand into more scalable architectures. Our main challenges came more from the design portion, because Stark Law Review is the kind of review that differs from firm to firm. Everyone has their own system. Everyone has their own due diligence process, and there's no single process. There's no solution for this. Sort of no unified solution for this. So the partners we were working with, we basically had to go sort of case by case, analyze what kind of questions do we want to ask. How do we want to do this to make it as short as possible and to already get some meaningful info at the very earliest stage. So I would say design was taking up more time than actual development and programming, which is a good thing, really. Technical issues shouldn't get in the way of design.
Thank you.
I have just a quick observation, which is this is fabulous. And the thing that immediately jumped to mind for me is this looks a lot like some of the challenges that we have where we're thinking about trade issues, where there is an organization and there may be related organizations, and you want to understand what the relationships among those organizations are. And so as a next step to this, I do wonder if this gets even more powerful if you have the ability to, partner with a data provider, perhaps like a Thomson Reuters, and start bringing feeds in that give you intelligence about what the relationships are among organizations. Because when you're talking about scenarios where you have good faith actors, but they're trying to not, step into the bear trap, giving them a view on what that network of relationships are that might reveal risks for them they didn't even know about, like that starts to get really interesting. But I think this has great potential. Fabulous.
Absolutely, yeah. I mean, we've had this. This was only thrown as a concept because we didn't really have the resources or time to develop. But one of the portions of the review in the STAR Club process is to analyze fair market value for services and any kinds of kickbacks coming back to the physician. And this is the kind of thing that you cannot. There's no single system that could analyze this for you. So this can also sort of benefit from creating a network where we have information from other physicians on what the average value of certain services is, or things like paying for your office, or the cash benefits that you receive, any presents or gifts you receive. There's a lot of information that could really benefit from being sort of integrated into a data science network or pipeline and then put into this application. Absolutely.
All right.
This is Alex.
Go ahead, Alex, if you want to add something.
Hey, just to add really quick, one of the things we learned along the way is that even within the physician group, you have different kinds of physicians and they have different levels of knowledge. And so this tool maybe isn't great for a physician at Northwestern Memorial because they don't know about various things. It's maybe better for a small town doctor or these physicians that they know who they're giving the referrals to, they know about their patients. And that was just really interesting to kind of peel away the industry and get a deeper look into what's there.
All right. Well, great. Well, thanks to our Honigman team and for our project partners on that. And thanks to our expert panel. We're going to keep things moving and we're going to move over to the Orrick team. So is the Orrick team ready to go with their presentation?
Most certainly. Is my screen being shared correctly?
Yes, we see it. It looks good.
Perfect.
Awesome. So hi, everyone. I obviously just want to welcome you again and thank you for joining us. We're really excited to share about Orrick's oral argument flashcard generator. So just a quick introduction to the team. My name's Ines, and I'm a student at the Northwestern Pritzker School of Law. And from the McCormick School of Engineering, we have Zane, Julie, Brandon, and Taehoon, our developers. So what is our project about? Well, our client Orrick is an AmLaw 100 firm attracting truly top-tier attorneys to do cutting-edge, high-caliber legal work. But Orrick is currently struggling with a problem. Orrick's Supreme Court and Appellate group prepares for oral arguments roughly 25 to 30 times a year. And part of this preparation includes reviewing briefs and manually creating Q&A flashcards to be used during this preparation process. The reason for this is that judges often ask attorneys questions that cover a very broad scope of information and can vary from key areas of the record to seemingly minute details. And really, for that reason, it's absolutely critical that attorneys know the record cold. I thought we could go through a hypothetical for a second just to illustrate how this manual flashcard making process can impose some real significant hurdles. So imagine you yourself are a mid-level or a senior associate, much like our partner, our Orrick partners, who have been practicing litigation for quite some years. At this point of your career, you've maybe even led depositions, ran a case, and conducted a client meeting. Now you've been asked by a partner to help her prepare for a Supreme Court or appellate oral argument by going through all of the filed legal briefs by both your side and opposing counsel and generating quiz material from those briefs. Now this is stressful because of really two big reasons. First, there's a lot of information densely packed into these legal briefs that the partner may need to know, as I mentioned before. So making these flashcards can be a very time-consuming process wherein you go line by line and pull out information because, to be quite frank, you're not really confident on what constitutes important information on this particular case for this particular judge. So problem one, truly time-consuming. The second problem is that it's really tedious and most likely not the level of engagement you wanted to have with such an interesting case. Not only does this project take you several days to complete to a satisfactory level, it also ends up taking time away from other projects and work that's arguably more stimulating at this level of your career. So what do? Well, naturally, your brain starts thinking and searching of ways to complete this task more expediently and efficiently so you can free up that time for more challenging matters. And that's precisely what Orrick asked us to do when they approached us with this project a few months ago, to really find a way to create an automated process that would streamline the creation of these oral argument flashcards to help prepare their attorneys in the most cost-efficient and effective manner. So I'm going to hand it over to Zane to talk a little bit about our approach.
Thank you, Ines. And so let's do another little exercise. Let's put ourselves in the shoes of an associate and go through an example of a brief that we may be tasked with making flashcards from. So this is an actual example of an Apple answering brief that Orrick had provided us to generate flashcards based off of. So let's just go through this. And as an associate, this is my first time being acquainted with the case. So it'd be best if I would create as many flashcards as possible, going sentence by sentence, such that we could prune them later. So let's scroll through, and the table of contents is the perfect place to start. We can get a great overview of the case, the introduction, the statement of the case, summary of the argument. Arguments are the best to generate these flashcards from. We have argument 1A, 1B, 2A, B, and C. We have argument 3A, B. Oh, geez, we're already at page 60. So that's a lot to go through, but let's start it off. Let's go to our first relevant section. Let's go down all the way to jurisdiction. So perhaps we can generate a question based on the first sentence here. The court has jurisdiction under so-and-so, counterstatement of the issues. Maybe we can break this up into a question or two. And so on and so forth, and sentence after sentence, generating these question-answer pairs. And as you can tell, the process of generating these question-answer pairs from these briefs can be very time-consuming, and I'm even going through this process rather quickly. So I don't know about those in attendance, but I'm already getting quite bored of this tedium. And as a lawyer, I need my flashcards to be generated in a timely manner and with me at all times. Waiting days for flashcards to be generated is unacceptable in today's day and age. So let me just speed things along with our application, rather. And let me bring this up. And here is the brief that I just showed you. And let's drag and drop that. Ah, much better, isn't that? So these are some of the actual example of the question and answer pairs that our model generates. And so we can scroll through all of these. And so let's pretend that I'm an associate on the way to give my oral argument. And if you know anything about Chicago traffic, it takes forever to get anywhere. So wouldn't it be convenient if I were able to quiz myself during my commute? So for instance, let's say that the standard of review, let's see what questions we have for that. And if we enter quiz mode, the question is, what is reviewed for abuse of discretion? And the answer, of course, is a district court's class certification decision is reviewed for abuse of discretion. And all the while, I'm preparing myself to win the upcoming case. And so our pipeline is actually quite simple. That sentence by sentence approach that I showed you in the brief is actually how we tackle this problem. We take the brief as a whole, we break it down into its relevant sections. From those sections, we break them into sentences, and from each declarative sentence, we're able to generate question-answer pairs that we make these flashcards out of. And so let's talk about the performance of our model. Building as a baseline, let's remember that we're up against a multi-day task for associates. Our pipeline has been improving significantly with each iteration. And now it only takes roughly 20 minutes to process an entire brief. Pre-processing the brief takes mere seconds, but where the actual bulk of the time takes is with generating the question-answer pairs, which takes roughly about a half a minute per page. And to get down into the weeds a little more, that's because with each sentence, declarative sentence, we're able to generate 0 or more answers based on that sentence. And then from the 0 or more answers, we're able to generate 0 or more questions. And then from those combinations, we're able to rank them and choose the best question-answer pair from only that one sentence. And we have to do that over each sentence in the brief. So what's next? So first and foremost, we'd like to minimize the amount of time it takes to generate our flashcards. And lucky for us, computers are so smart that they generate the question-answer pairs in tandem, comparing this to a human that can only generate question-answer pairs sentence by sentence. Second, we'd like to encode better grammar checking and resolution techniques. So our model currently generates hundreds of question-answer pairs, and yet we only show the end user the most grammatical pairs. This is because we either try to improve the grammar of a flashcard or remove it entirely from our output if it's really ungrammatical and rather nonsensical. So better grammar resolution means more flashcards. And lastly, it would be great to be able to get feedback from our legal users and be able to use that feedback to better train our model to output better question-answer pairs as a way of the model to self-improve itself without additional human interaction. We'd like to thank all of those in attendance, and we'd love to give a special thank you to our Orrick partners, Manyi Chow, Katie Kopp, and Melanie Halloms. Thank you, everybody. Are there any questions?
Great, thank you, Orrick team. So Khalid, Jason, and Farah, questions?
I have lots of questions. So listen, this is really exciting, and I realize this is sort of a time and resource limited project, and you probably didn't have a chance to do this. But you started with trying. The essential problem is you wanted to time optimize attorneys, yeah, to make them more productive. But you didn't tell us about any experiments or any validation, regardless how small, about does this actually help attorneys be more productive, more efficient? Any comments on that?
Yeah, so that largely came down to a time issue where the problem was bigger than the quarter-long scope than we were given.
Of course, yes.
The majority of the time was figuring out a model that actually did the question-answer generation, the ranking, and then the grammar checking. But that is definitely something in the scope and something that we'll consider going forward.
Thank you. I can go on. Go ahead.
Well, let's take turns, just to keep it lively. So first of all, I love this idea because having been, an attorney at a big firm and starting out as a baby associate, I had to do stupid assignments like that and make flashcards. So this really hits me in my heart. And I appreciate that you're trying to take that drudgery out of the process and make it more user friendly. So A+. My question is there, do you perceive that there could be a gamification aspect to it as well? That if multiple people, let's say, are prepping for the same argument, there'd be scoring and an ability to say, well, this one has reached the threshold of preparedness, but that one sucks. Where do you see this going?
Oh, most certainly. With our flashcard, we have that quiz mode, and we haven't been able to fully develop it to its fullest extent, but we would like to be able to star certain questions if you'd like to go back to the hard-hitting questions. And quizzing yourself among your fellow associates would also be rather entertaining. But yes, most certainly, the gamification of this entire process and studying them would better prepare the associates for the oral arguments.
So I'll make an observation about what I see. Like, this is very interesting. Of where I see the most value being created from this. If if we're really honest, at least in the appellate scope, we are often not quite as cost sensitive, at least on the client side. I'm not saying we're not saying we're not, just not as. But what gets really interesting is what you pointed out on the front end, which is really your biggest challenge is human attention, right? Like that's really the greatest scarcity we have going forward. And so where this really intrigues me is going to your second phase, when you started talking about piping more data back in. So what would get really interesting is if you have a firm that has a very robust appellate practice and they actually start coding the questions that happen at oral argument in the appellate context, so you can like really prioritize the stuff that is most likely to be hit. And if you actually gave people a data-driven approach to their investments, this starts to become this amazingly powerful tool. And so I think you have the building blocks of something that is just fabulously useful. My question is, so how are you, right now, how are you ranking the best questions from each section? Like how do you decide what pops?
So from the original paper that we based our model off of, they automatically do this through very fine-grained grammaticality, where they take the parts of speech of the question answer pairs, and if it doesn't flow correctly or it doesn't make enough sense, it ranks them accordingly. And then from there, once we get the highest ranked question answer pair from each declarative sentence, then we're able to do an overall grammar checking to further prune what we output to the end user. Mm-hmm.
Got it.
I think that's a good point. I think you will probably get better results if you did question unification at the issue level, yeah, because in addition to testing or prioritizing or ranking questions from a grammar perspective, from a sort of lexical perspective, not all the questions are created equal, and the attorneys on this panel sort of know this more than I do. Questions about black letter law are not necessarily as important as a hypothesis that someone is trying to apply to the facts in a brief to reach a certain outcome. So some function that identify these hypotheses, as opposed to a statement of fact or a statement of a jurisdiction or a statement, will probably be needed. And I realize this is much more, much broader than 1/4 kind of a project. Yeah. But
So
really good work. Yeah.
If I can throw one other thing in there. So what you have here also is a fantastic defensive tool for what is to come, because what will happen over time is more semantic analysis is going to happen that's going to influence the theory of cases. And to the extent that that is that is the sword, then what part of what you're giving is a litigator part of the shield as well. Because if you can basically figure out what is the likely approach that the other side is going to take, then you can get even more focused about giving the person who needs to basically argue against an argument what it is that they need. Or flipping it over, if you're analyzing some of the weaknesses, it gives you the things that they should go on the hunt for when the door opens on oral argument. So I think what you have here is something that's probably going to become more and more relevant, just as both offensive and defensive in the future. Very cool.
I love it. Sign me up.
All right, great. Thank you, our team. Thank you to our experts. We're going to keep things moving, and we're going to move over to the Cook County State's Attorney's Office team. Team, are you ready to go?
Yes.
Yeah. All right, take it away when you're ready.
All right, hello everyone. Thanks for joining us in the presentation. And our product, Mobile Shield, aims at helping victims to get an order of protection confidently and safely. And, this is our answer to the grim situation that on average, 24 people per minute are victims of rape, physical violence, or stalking by an intimate partner in the United States. So working with our clients, Cook County State's Attorney's Office, our team member include 2 law students, we are LM student, which is Juan and me, and 2 CS students, which is I and Sarah. Specifically, to get an order of protection in Cook County, you must fill a 12-page long petition form full of legal jargon. It's a time-consuming and complicated process. So after interviewing actual victims and our clients, we evaluate all the frictions that may encounter in filling a petition form in this matrix. And because we only have 1 quarter, we only focus on 3 crucial problems feasible to solve, given our time frame and resources. So the first problem is now the only tech-based solution to fill out the petition form is a desktop-only website, but many survivors only have access to a phone, so they cannot access the ready legal help. And second, the current experience of filling for an order of protection is cognitively overwhelming with this visually crowded interface, and it's emotionally draining as well, since users can easily feel confronted when being thrown 8 questions at once. And our real victim can lose hope and confidence, which isn't much to begin with, and give up petition as a result. And finally, our interviewee told us that her abuser will break into her home, will go through her phone, and pick out the things she was saying about him. So notice there are 2 noticeable use cases here. What if the abuser peeps from behind the victim when he or she is actually filling from our product? And after he or she quits the web page, what if the abuser hits show the previous page and check the browsing history? So in summary, we believe victims need a mobile tool with digestible information, a hopeful tone, and a safe escape mechanism. So starting from these principles, we build our solution.
And here is how our demo looks like. So as we talked about before, we wanted to limit it only 1 question per page. And to fill this form, there are roughly over 300 questions. And for some questions, probably users don't understand a certain word, so they can click on the pop-up button and to see the details or extra information for it.
Hi, sorry, I don't want to interrupt. I don't think that we can see the demo. We're still on the slides page.
Okay, sorry about this. How about now?
That's good, thank you.
Yeah, all right, I will start over. So yes, this is how our application looks like, and we wanted to limit only 1 question per page. And so for certain questions, if the users are not sure about the wording or they want to get extra information, they can click on this pop-up button and there are the answers for or explanations for the questions. And so let's just try a little bit. And so there are roughly 300 questions, and you can see from the progress bar, we're still in the really end of this whole process. And here is the one that already clicked through all the questions and go to the last page, which is the this download page. And if you click on the download, the form will be right here, and this will how it looks like based on your based on the user information. And back to the first browser I opened, I want to show how the escape button really looks like here. So once you click on the escape button here, our application actually will mask over the browser history by this Reddit page. So, and also if you click back, you couldn't go back to that form fill-in system. So this is pretty much the demo.
Great. Thank you, Cook County State's Attorney's Office team. Khalid, Jason, Farah, questions? Or one, I'm sorry, am I interrupting? Did you have a little bit more?
Yeah, we're just.
Oh, I'm sorry. Go ahead.
Don't worry. So from our interviews and analysis, we found out victims of abuse, and people usually respond better to one question per page and keeping it simple and redacted in plain English. So we could say translated the legal terms of the petition form into plain English so victims of abuse could understand more easily. We also included the progress bar, as my colleague was saying, to indicate how far along the process they are. The questions have logic nested into them, so they only pop up if the victim answers them a certain way. And we also put in celebration milestones, that's what we call them, to empower victims to finish the whole form, to give them reassurance. And that's what we found out, that psychology in these cases is really important. So we have pop-up notices that pop up throughout the presentation of is reassuring it's not their fault, the situation of abuse they were present, and with positive quotes as well, and a way for them to reach an external resource in case they cannot finish the form or the form is not right for them, so we can put them in contact with other organizations. So for our product, we want to incorporate a session timeout feature into the web page. So if the victim doesn't answer in a certain amount of time, the web page will just load to another one. We also want to incorporate that it could only be done during incognito mode, so to better protect the security of our users. And we also want to incorporate auto-save answers, so create some data storage servers for the answers to be saved in case they cannot complete it in one run. It takes approximately half an hour for all the questions to be completed and then printed into the petition. And then within the current justice system, we would like to incorporate e-filing to our website, because now it's not possible for the order of protection to be filed electronically, and victims have to download the file into their phone and then print it and present it to the court. So that puts an extra risk into our users. And we also think providing us an official set of answers would be ideal, as experts could point out the most important things victims have to keep in mind when answering our form. So now if you have any questions.
All right, great. Thanks, Cook County State's Attorney's Office. So Khalid, Jason, Farah, questions?
Well, this is Farah. I applaud you, because I got to say, hearing that it's a 12-page form that can't be filed electronically and that has 300 questions is horrifying. You know, we'll talk about impediments to justice. So I think you've tackled a really, really important issue with a lot of sensitivity and EQ, that you're thinking about the real experience of someone who has to go through this and what is it going to take to get them to where they need to go. So my kudos to you, because I think this was not only a well-selected issue that needs some fixing clearly, but also one that you tackled not only with the technology, but real design thinking as well. So I don't really have a question. I just wanted to give you that feedback that I think this is very meaningful work.
Thank you.
Thank you.
I'm happy to jump in with a question. But yes, this is fabulous. So I guess my my top of mind, it really jumps to patterns, in as much as when you have 300 questions, I do wonder, is there a way to abstract back a bit so that you can give people patterns and templates that, you know, because, and I don't want to reduce the experience of people who are, you know, are experiencing domestic violence, but I do wonder if, you know, if I'm in a state of distress, are there typical patterns where that gives me a template so that can speed me through this process? And I'm just wondering if you thought about that at all. The other thing that I find potentially really compelling about this is, if we think that the general pattern of these crimes and the people who are experiencing this is similar in the real world, is there a way to take what you've done, and if you abstract it in the right way, create something that works across jurisdictions? Because the outputs might be different in Cook County or other places, But if you really think about the facts and circumstances that cause someone to seek a protection order, they boil down to the same patterns. And can you take what you've produced here and effectively emit to different jurisdictions based on where somebody is?
Yeah, what we did with the questions, like even though there are 300, we nested them inside our program. So they would only show if people answer a certain way. So a victim could only maybe answer 20 questions instead of the 300. Maybe the 300 is an extreme case. So we added some logic for the questions to only be shown. And if they do not apply to your case, there is no need for you to even know the questions or for them to be answered. And then I think the point you make about cross jurisdiction is something really really important that could certainly be incorporated. The questions I imagine would be quite similar, and it would just change the output document, which is something I think our product can do at the moment.
All right, I'll add something about the patterns. And I appreciate that you bring up this question because that is certainly what we have given some thoughts about. We actually, so during our research, we actually went through the Reddit's communities of domestic violence victims and identified certain, I would say, personas, like the mother who wants to leave her abused husband with a child, or like unmarried like young girl who want to leave her boyfriend, are facing with two different situations, and their answer to the question can be drastically different. So yeah, it definitely will be helpful if we can just let them select the personas at first and pre-fill the questions accordingly and let them modify the results. But we didn't give that much thoughts into actually building the persona into functions or features. So I really appreciate this suggestion. It's really been helpful. Yeah.
Have you considered having I'll call it a break the glass option? You know, let's say somebody starts engaging, answering the questions, and notwithstanding all of the helpful celebration milestones and all the other features you've added in, they find themselves overwhelmed. Is there going to be, or are you considering some sort of functionality where perhaps they could click on something to make a connection with a local attorney who could guide them?
Yeah, and one of the things that we actually spoke about with the young woman that we interviewed during the process was that, and one of the things that she pointed out was that it would be great to have a sort of discrete way of connecting through the application with a local legal advocate's office, like a chat within the application, so that again, we try and minimize the amount of interaction that an abuser could be tracking on the technology. So that's something that we definitely within a larger time span, that would be one thing that's really important for us to implement.
That sounds great.
No questions from me. Love the idea, love the app. I really love your design principles, especially the safe escape mode. Very clever.
All right. Outstanding. Okay. Thank you, Cook County State's Attorney's Office team. We'll keep things moving. So the Bluhm Legal Clinic team, are you ready to go ahead and take over and present your project?
Yep. All right. Good afternoon. Yes, we are. So good afternoon, everyone. We are Team Eviction Guides, and we have developed an eviction court navigator in partnership with the Bluhm Legal Clinic here at the law school. And before we get started, some introductions. My name is Jonathan Deitch. I am a second-year JD student at the law school.
Hello, my name is Caroline Ford. I'm an LLM student at the law school.
Hello, I'm Japung Pan. I'm an SL student in law school.
Hi, I'm Alan Farkish. I'm an undergraduate studying computer science.
Hi, I'm Sundar Taylor. I'm an MSAI student at Northwestern Law.
Hi, everyone. I'm Mike Barr. I'm an MSAI student.
So to kick things off, just an overview of the problem we were challenged with at the beginning, and that is you've received an eviction notice and you don't know what to do. And here's some background on this. Almost 90% of tenant defendants in Cook County Eviction Court are self-represented, while roughly 80% of landlord plaintiffs have adequate legal representation. Worse yet, many tenants fail to appear for their court dates and end up with default orders against them. So what we've devised as a solution is an eviction guide, essentially, with two primary features. We allow tenants to plan their defense, which we hope will facilitate more competent self-representation through organization and preparation. We also strive to make the day of their hearing more comfortable by providing important information about the Daly Center facilities in one user-friendly location. Basically, we gather information that was in a number of different spots online and bring it all into one convenient, almost FAQ. So Eviction Guides was inspired by the Arizona Eviction Guide in part, a similar tool actually built by the lab at Stanford and deployed in Arizona. Our tool offers a simple web-based guide that includes dynamic graphics, actual photographs of courtrooms and Daly Center facilities, form court orders, etc., which we believe can help acquaint and orient self-represented litigants to eviction court, which we hope will result in better outcomes and or reduce the default rate. The bottom line is that this is a very scary process that tenants typically have limited experience with compared to their landlord counterparts. If nothing else, we hope to accomplish a leveling of the playing field by creating comfort and equipping tenants with basic knowledge to tackle this troubling circumstance. So I will turn it over to Alan for our demonstration.
Awesome, thanks, John. So our solution, as John said, is a website. So here's the welcome page to our website. We do have a welcome video that explains the features of the website and who it's for, similar to what I'm doing now. So without further ado, we'll get started and enter the website. So we have four main features here. One is to plan your defense, to determine if you have a defense and even view a sample statement that you can tell to the judge with references to the legal code. We have directions to the courthouse, including how to get there. We have a lot of convenient information all in one place here. And we have a direct link to the Cook County Clerk of Court's website and their electronic docket search. So we'll go through the plan your defense feature now. So in this feature, you're prompted with a series of questions and you have to provide the answer. Most of the answers are pretty simple. And then for each question that requires you to look up information, it's going to have where you can find that information on either your lease or your eviction notice. So do you have a standard year-long lease? So our client has told us that for people who have different types of leases, their cases might be more complicated. So to direct them to the Bluhm Legal Clinic instead. And then to continue with our application, we'll say yes. Why are you being evicted? The two major reasons for eviction are non-payment of rent and violation of lease provision. This time we'll say I could not pay my rent. Were you given a 5-day eviction notice? So landlords are required to serve tenants that they are evicting with a 5-day eviction notice. So we'll say yes. And then we have a checkbox list. For this example, we're going to say that the landlord accepted partial rent. We'll hit continue. And here's a summary of the information inputted so far, just so you can double check. And then a brief explanation that's easy to understand for anyone of the law as it pertains to this issue and this defense. And then finally, we get a sample defense statement that you can actually read to the judge. We'll go through this one more time. The really interesting thing about this feature is that you can stack defenses, so to make your case as strong as you could. So this time we'll say that we were accused of violating the lease provision. For a violation of lease, you're required to be served a 10-day eviction notice by the landlord. So we'll say yes. And let's say that whatever the problem was fixed in time and you believe that the landlord is evicting in retaliation. So we'll hit continue. Again, a summary of what the site has collected so far. And then a brief explanation that is easy to understand of what the law says about this. And then finally, a sample statement that you can read to the judge during your eviction hearing, complete with references to the legal code. Next, we'll see the directions to the courthouse. So we have a map here with the Daily Center in the middle in the loop. We can also view ADA accessible entrances, parking places for those who are going to drive to their hearing, and public transportation is already shown on the map. Finally, we have this FAQ. Has lots of resources all in one convenient location and in language that is easy to understand by anyone, such as what to bring to the court date. So we have resources for before the court date, on the day of the hearing, and then resources for families. So on the day of your hearing, you might need help getting there. You might want to know where the help desks are. And we have images from the courthouse as well. And then resources for families such as the child care room. And as I mentioned, this is just a link to the Cook County Clerk of Court docket search website. Okay, I'll hand it back to John.
We can open it up for questions to the group. I see you might still see on our screen our future work slide. We can incorporate that into the Q&A as we are out of our allotted time at the moment for the presentation component.
Great. Thank you, Bluhm Legal Clinic team. And so I'm going to turn it over to our expert panelist. Luke Cannon from Chicago Innovation is now with us too. So we have all four of our expert panelists with us now. So Khalid, Jason, Farah, and Luke, take it away, please.
I guess I'll go first. So very cool. And honestly, I just have a list of feature asks. I'm like, wow, this is great. Here's some other stuff that might be fun. So one thing that just jumped to mind is you have this this great opportunity to potentially have the customer effectively take whatever their rental document is and upload it to a service so that gets automatically processed for them. So that seems like something that might kind of speed things along and starts to give you some interesting data learning opportunities so you can actually see the species of different types of agreements, because there may be other defenses that show up if you process the lease and you start seeing things that are not permissible in a lease, but that, you know, if you don't have counsel, they wouldn't actually spot that for you. One of the things that you're doing that I really love is you're thinking about the user experience and like, what are the real practical challenges that they have? Like, because just even figuring out like where to get to is cognitive load that if you can take that off them, that is just gold. And so one thing that jumped to mind that would be maybe a small thing to add is if you actually gave people an experience that is a scheduler, right? So that they start getting text messages that like, let them know like, hey, your date's coming up. You know, you should prepare yourself, and like starting to give them kind of markers that say, you know, these, like, you're 3 days out. Have you practiced your statement, things like that. But this is just really cool. Great job.
So this is, oh, go ahead.
Well, mine's I'll go quickly. So first off, I also think it's rather brilliant, and with Jason's additions, I think it's brilliant plus. Yeah, I think this is really great, guys. My question's a bit more general, I think, which is just, you know, did you see if there's anything like this that already exists? And if not, do you have a sense of how your target population is currently addressing this pain point?
So
Yes.
Caroline can take this question.
Okay. Thank you, John. So yes, there are definitely already some websites available, but they're not targeting the same issues and don't provide the same answers to tenants. I think what our website is gives more general information about eviction and not, so it's more straight to the point, and it's not just a chatbot. And also, I think the main feature of our website is that it provides a defense that the tenant can only just read to the judge. So it makes the process of for the tenant way easier and less stressful. Also, the navigation guide through the court is something that other websites don't do. So I think even if there's something already out there, our website completes more things.
Gotcha. Well, I'm sure there's gonna be a lot of people who are gonna need this exact thing coming up on May 1st when rent is due again, and just given the crisis going on. So seems like a really smart product at a really needed time too.
So this is Farah. This might be a bridge too far, but I found myself wondering when I was looking at this, which by the way, it's great, as everyone is saying, would there be an ability to tap into history, if history is to be any guide, and to know if a particular landlord perhaps has a pattern of eviction, and when those evictions happen, what are the arguments that carry the day as opposed to the ones that don't? I'd be interested if I'm getting evicted in knowing that this landlord does this consistently, through the years, but that judges have tended to say, okay, when your defense is X. So that would be a great way to tap into perhaps some of the public filings that are out there and determine, some predictive outcomes.
I think to piggyback onto that, it's a great point, and it's well taken. I think what we saw as the low-hanging fruit here is that a lot of tenants in these cases just aren't showing up to begin with. So to make it as our first step, just to show up and have something to say, be prepared, be organized, we're already making significant inroads. But absolutely, to make it smarter and to add these landlord histories and all of the patterns and sort of a sense of which defenses work, that's a great idea for next steps from here. Thank you.
So I think we have time for one more question from our panel, if you have any additional questions.
I did have one more. Did you consider another mode, which is you're about to be evicted? Here are the things that you might want to do that would cause you to not be in an unlawful detainer situation.
So we hadn't gone that far, but again, it's another awesome idea for something that we could build on with this. I think avoidance would obviously be a good form of mitigation too. So yeah, we can add it to our list. Thank you.
Okay. All right. Thanks, Bluhm Legal Clinic team. So this team worked with our Northwestern Law School Bluhm Legal Clinic. Thank you, team. And next up, we're going to have the team that worked with Thomson Reuters Labs and Judge Wilfredo Martinez. Team, you ready to go?
Absolutely. Stand by, please. And good evening, everyone. Thanks for joining us today, and especially thanks to our project sponsors who we'll introduce in one moment. So our project was Project Traffic Light, and our challenge was to help court judges become more aware of subtle indications that many people appearing in their courts, who were usually criminal defendants, were actually victims of human trafficking themselves. We titled it Traffic Light in that we wanted to both illuminate and help stop human trafficking. In our team, we had 2 students in the Master of Science Artificial Intelligence program, Akash and Nalanchi. We actually also had an undergrad in our team, Bijal, Computer Science Social Policy, and then Shen and myself in the Master of Science of Law program here at Northwestern. And then Akash.
Yeah, thanks for the intro, Eric. And we'd like to thank our project sponsors, namely Judge Wilfredo Martinez from the Orange County Court, and also Brian Ulsony from Thomson Reuters Labs for their expertise and insight during every step of the way when we built our tool for like the knowledge base and an expert Q&A system for like handling the human trafficking cases and giving us suggestions. And kind of to give an overview, like while we were crunching the numbers from the counter trafficking data collaborative and also like exploring the global problem of the human trafficking, we have seen that there are almost like more than 40 million cases worldwide accounting human trafficking, or like which have been like a subset of this scenario, and this can be defined under the use of like use of force or like exploitation and eliciting various kinds of activities, and also like forced labor and sex trade also accounts to a like major amount of the capital which is generated in regard to the human trafficking, as you can see the numbers on the slide. And I'll give it over to Shen.
The judicial awareness. So many defendants are brought to the court being accused of shoplifting or prostitution, but the defendants, as Eric mentioned, that they could just be the human trafficking victims who had no other choices. So they're consequently punished and released and went back to the forced labor again, and the problem is not really solved. Because there's very limited funding for the training programs in the legal system, and our solution is to come up with a bench card. For the design of the bench card, we include a few sections, such as sections successful to human trafficking, the legal definition according to the Trafficking Victim Protection Act of 2000, reflex and triggers, case management tool, and at the bottom, we attach the link to our Traffic tool for further evaluation.
Thanks, Jen. We're going to jump into our demo. We designed a tool for simplicity was the main key, as our expert in the field, Judge Martinez, emphasized that the amount of time a judge had to actually take a look at a defendant and make that extra analysis of whether or not possibly this person is being coerced or controlled, or if they committed a crime because they were forced to, as opposed to just because of factors inside their own lives. So as you saw on the bench card, we have a individual passcode. So each bench card would be issued to a specific judge or courtroom and would reside physically on the desk of the judge. With those passcodes, we can identify where the information is coming from, which enables sort of restricted access to the system, and then also enables anonymized data collection, so that we can actually begin to collect data on the back end to understand who's inputting this information and possibly what the different characteristics are depending on where they are. That's going to be a future aspect. So input your passcode, go to the next screen. So purely as an information gathering tool, we'd like to get some demographics. And on my first run through, we're going to have a 17-year-old female, and one of definitely the most fascinating and a unique combination of factors that indicate human trafficking that Judge Martinez exposed us to was a combination of identity theft and grand theft auto. So enter the information. So the first listing on the bench card is for involvement in a sex trade crime. So that's no. Are they involved in ID theft and grand theft auto charge combination? And so it turns out that Judge Martinez laid out a very specific fact pattern that he grew tired of seeing because it was so repetitive, and said, this is an indication of organized crime and of human trafficking. So especially in Florida where he operates, there's a lot of sporting events. And what happens is a man flies in to attend the sporting events. Once he gets into town, he hires a prostitute, takes a prostitute to a hotel. Before she renders her service, she asks the man to take a shower. While he's in the shower, she steals his wallet, the rental car keys to his rental car, which he has because he's from out of town, and flees the hotel room, and then delivers the keys to a getaway driver who takes the car, usually to a chop shop, and then takes the wallet and credit cards and gives it to an operating, basically, identity theft computer lab, which might actually be in the same hotel where she is operating. And in that lab, the identity thieves will max out the credit cards, and then we go from there. So what happens is there's a combination in the courtroom where the identity theft victim is not present, does not press charges. They're probably married, they're from a different state, they don't want to have anything to do with the criminal procedure. However, the credit card company is a plaintiff. The grand theft auto usually results in a chop shop, but let's say we don't know that actual detail. The victim is not there of the ID. Is the plaintiff also a rental car company from the theft of the car? That we know for sure. So that combination of factors, again, speed was key, simplicity was key in the user experience. So the judge uses this. It's a high indication likelihood of the victim of being human trafficking. What the judge can do within their bandwidth is hopefully refer the victim to social services, or barring anything else, possibly consider a lighter sentence or providing some sort of guidance within the time that they have. So the second situation would be, so we're going to suppose a 17-year-old male, and another indicator was accompaniment is what we called it. So victims of human trafficking often are accompanied by someone in court who is not related to them and is much, much older. So they're not part of a sex crime. It's not ID theft. It's not shoplifting for basic necessities, which is another. Do they have a handler or overseer present? Well, there is an older person present. So do they defer to the third party before answering any questions? That's a solid indicator. Does that third party even attempt to speak from the court gallery? Is the defendant much younger, but the third party is older and not a family or legal guardian? So at this point, perhaps the judge might say, I see you know that person in the gallery, who are they? And if the defendant says, oh, that's my uncle, he bailed me out when I got arrested the first time. Okay, well, you know, they're a family member, so it's not an indicator. So we don't have any secondary indicators. So what happens is the tool puts the user through more questions just to ask them to make sure. If they thought someone might be a victim of human trafficking, well, let's just make sure we ask some more questions. So another main indicator was just a very spaced out and confused disposition while they were in court. Repeated driving while license suspended charges, another indicator. That's not the case. Another big indicators was brands from burning or abuse injuries or stock keeping tattoos such as zebra codes. And they don't have any of those. We also want to consider employment information. Let's say this gentleman has no occupation, so that's not really an issue, so we have none of those. And a final check through. You know, do they have a whole bunch of flashy objects that don't match their income level, or has someone been supporting them while they've been held in jail with money put into their spend kitty so that they can maintain perhaps their looks or their makeup, so that honestly they're ready to go once they get released if they are in fact a human trafficking victim. So we have none of those factors. So we need more information. So we don't want to make a solid no, but the judge has looked at this person, thought about it, and said, you know what, they're probably not likely a victim. I'm glad I took this. So moving on to the next steps. If we could automate this system, if we could get digital access, if we could get court records and digest them with artificial intelligence tools, we could use the digested data to drive automatic tool operation, which was actually our goal originally, but we didn't have access to court records. They're incredibly difficult to get a hold of and to digitize. If we could use an analysis tool to read live court records as they process through the courts, we could automate a flagging system for judges. We could give them a light on their desk that blinks, a flagging system for documents that as they come out. And that would be, ideally a next step. So at this point, we'd like to thank you all for attending, and then wrap up and take any questions that you may have.
Great. Okay, thanks team for your work with Thomson Reuters Labs and Judge Wilfredo Martinez. And I'll turn over to Khalid, Jason, Farah, and Luke for questions.
Hey, this is Khalid. Thank you guys. Really excellent example of the use of sort of technology and data science to solve a real problem. My question was really about the data, but you indicated that you didn't really have access to data, because to me that is the real bottleneck. Is getting data to be able to analyze it and cover and discover patterns that you can incorporate into the tool. My only comment is, it would be nice to have a progress bar on the questions, especially if it is no, sort of the user didn't really have a sense of when is this going to end, etc. But really nice work. Thank you.
Thanks. We thought about that along with a lot of factors where it was maybe yes or maybe no. We definitely defaulted towards simplicity. Because we refined our usage case down to simply judges in the courtroom as opposed to, say, probation officers who would also be excellent users of a tool like this. If we knew that there was a single user and they were going to acclimate quickly to the tool, that they would understand how long the flow took. So definitely 300 questions from, domestic orders of protection is one thing for first-time users. So yeah, that was a tough call often of, hey, we've got this feature, we want to include it, but how simple do we try to make it so that it's usable on the smallest cell phone screen possible? So thanks for that input.
Thank you.
I'll jump in and go next. First, I just want to say, I know I've only listened to this one and the last one, but I have a lot of faith in the future legal entrepreneurs of America, because this too is just, I thought, a brilliant idea, something I've certainly not thought of, but clearly is a real issue. I thought the insight into the Florida example was really, really interesting, and that there was it's like a specific trend that judge saw because of the local component or even the regional quality. Right. You're thinking that, to Khalid's point, about building different kinds of data sets, would you look into other different regions have their own components of how human trafficking occurs, or is there different kinds of judges or different kinds of courtrooms? How did that factor into your thinking versus sort of like a one-size-fits-all approach of questions to ask?
Oh, absolutely. This is scalable in that if you have a skeleton of how it operates, this is definitely an Orange County, Florida tool. We would definitely gain expert knowledge from any courtroom that we went into and extract that knowledge and try, what do you say? Because if there's a construction boom in a town, the majority of human trafficking victims could be construction labor, or it could be housekeeping labor. In Florida, there's a very high level of tourist trade and constantly people coming from out of town. So there is a larger component of sex trade crimes that are involved. So absolutely, this is a regional tool that can and should be adapted depending on the individual circumstances.
So I thought it was great as well, and obviously important work. And so kudos to you. One of the challenges that you acknowledged towards the end was related to the availability of the data.
Right.
And I wanted to probe into that a little more, if you wouldn't mind explaining what is the challenge there, and do you have thoughts about how to surmount that challenge?
Sure. So we looked into Cook County. I mean, we started locally, and you can actually access felony records, but you cannot online or digitally access misdemeanor records, and you certainly can't access like a live docket stream of, you know, just doing a data pull of who's up to bat, who's in the batter's circle for today in the courtroom. The current global situation and all of the remote access that's happening now is definitely going to push it. I'm going to give credit to Kim Fox, state's attorney, who actually is doing, she did a hackathon to help people build software platforms to access that felony data. So there are positive actors inside systems that want to digitize. But on the other extreme, we have our Secretary of State of Illinois doesn't want to put the corporation registration information online as a publicly accessible information base. So it really does depend on who is in control of the information and how important they think it is to make it publicly accessible instead of holding a monopoly on it. So thanks for that.
Thank you.
My primary question was picked up.
There you go.
Great work.
Thanks a bunch. We appreciate it.
Thank you.
All right, great job, team, working with Thomson Reuters Labs and Judge Wilfredo Martinez. So thank you. We're going to keep things moving. We'll move on to the next team, which worked with the International Association of Contract and Commercial Management and Simplifier. So team, you ready to go?
Thanks, Professor Linna. Hey, everyone, this is Justin Che. I'm just going to share my screen. Okay, so at face value, our project is kind of billed as a contract review project, but it's really much more than that. The challenge in our project is to help the world agree, but what does that really mean exactly? Well, if you want to march globalization and needing for trust in uncertain times, there's been an explosion in contracts over the past 30 years, but the cost of inefficient contracting threatens to consume 10% or more of GDP, according to the IACCM. So why are we wasting time negotiating contracts and spending less time producing economic value? Well, it should really be no surprise. Contracting is an intensely private act. Parties tend to behave opportunistically in the hopes that they will get the best deal. But as it turns out, contracts are not quite as unique as lawyers might have you believe. In fact, the ICCM analyzed millions of contracts from the SEC's Edgar database and identified that people are frequently using the same components of contracts. Armed with this knowledge, the ICCM published their findings with great excitement. Unfortunately, there was little to no response from the community. Business leaders cited difficulty in integrating new standards and, unfortunately, no real business case to put to their CEOs. So to address this rate of adoption gap, our project sponsor, Rory Unsworth, devised Simplifier. The online contract negotiation platform has three parts. First, allow easy integration of contract standards. Second, measure their efficiency gains. And third, capture as much of that efficiency from the use of those standards. So this third area to the right is where we were asked for our help. So a negotiation platform has really two main components: easy drafting and easy reading. This other easy reading part is specifically where our team works. So given the ICCM and Simplifier mission, how do we approach this problem? So as a start, reading a document that contains known and trusted standard clauses is a start. Another technique is to alert the user when that standard has been changed. But a textual change might be long in terms of words, but low impact in terms of actual goals. So we also have the consideration for how we mechanically measure changes and then relate them to the user's goals. So to sum it up, our mission was to really enhance the Simplifier platform by building a method and UX to detect insertion of standards, estimate their importance in a legally safe way, and then present that situation back to the user that would allow her to have a rapid cognitive understanding, act on it quickly and efficiently, and then instruct the machine for similar cases in the future. So in order to achieve this mission, our team set out on 3 lines of effort. In the legal domain, Rodrigo there at the bottom, our legal expert and LLM lawyer from Brazil, provided insight into understanding what might be important in a contract. Using an NDA as an example, we generated a lightweight rule set using Excel. Then John, our computer science student, led our team, and he devised a way to detect and compare patterns in text and then relate them to goals. So with an understanding of what could be possible with the code, I took the task of developing an initial prototype. But as you can see, it's very busy. So after receiving early feedback from our client, we took some consideration for things like cognitive load. And also to produce some value, we tried to imagine what the platform might look like in mobile implementation. So for our bright idea, our team borrowed the idea of Grammarly for contract review. For those that don't know, Grammarly is a digital writing assistant that leverages AI tools like natural language processing to help people figure out the grammar rules in their documents. But instead of focusing on grammar rules, we propose that our solution focus on legal rules and analysis. So imagine an intuitive user action laid on top of document processing, powered by adaptive rule sets to help experts and non-experts in contract review on the Simplifier platform. So let's dive into the start of our demo with a review of what the story is going to be. Again, in this platform, we have potentially an expert, say example, a lawyer, and a normal user, just the CEO of a small company. So on one hand, we don't want to alienate, but we want to increase efficiency. On the other hand, we want to level the playing field, assist and educate. And then for all users, we want to achieve this, this high standard of high precision and accuracy while simplifying complex information. So I'm going to hand things off to John, who will go through a demo of the code that we developed for this project.
All right. Thank you, Justin. Let me just pull up my screen share right here. So as Justin mentioned, we have a scenario where we have two parties who are negotiating a contract, and we're trying to measure essentially what are the differences between two versions of the contract, as well, like quantitatively, as well as present that to the user. So in this specific example, we're using a standard NDA. So we have text version 1, or document A, and document B right here. And document B is a version of the contract after one cycle of contract negotiation. This could go on for dozens, hundreds, it could go on for one cycle, but what we're gonna do here is, what we did here was we came up with different ways of presenting the changes to the user to figure out what would allow the user of Simplifier to process what changes happened contextually, and reduce the load so that they can analyze differences in contracts. In addition, we wanted to spot the level of changes. So we have what we call routine changes and we have critical changes. And we developed a basic rule set using regular expressions to essentially figure out, hey, this part of the NDA template that was given was changed to a specific date or a specific party name. In addition, we also wanted to mark critical changes. So in this example, an addition of a liquidated damages clause was added to the contract. And so we flagged that as a critical change. Another thing that we wanted to do was have a quantitative measurement of the distance between the text. And so we decided to use this technique called word embeddings. Basically, we decompose the text into a vector, which could be hundreds of dimensions, depends on the size of your text. And we compare the difference between those two. Came up with this number for this specific example, which is small, indicating that there's not that big of a difference. However, the difference actually is great in this specific example because of the liquidated damages clause that was added, which introduced high risk in the contract to one of the parties. And so in the future, we want to work on refining this model, training better with more legal data sets, so that we can produce a more accurate number of the difference between two versions of one document. And I'm gonna stop sharing my screen now, and I'll hand it back to Justin.
Thanks, John. So you got to look at the kind of the heavy lifting on the back end. And so we tried to imagine what this would look like from user experience perspective. And so just a quick check, can you see my screen? Okay. All right, so we're looking right now at the current Simplifier desktop version, and you'll notice that we have a body of text, scroll bar on the left, and some information at the top. So what will this look like in the mobile version? As you know, we have less real estate on a phone, and so we decided to collapse the menu, for example, one quick change, and then go back and see compare. This menu is always existing, and we're trying to increase the real estate there. So to account, we envision a few ways of communicating changes in this NDA scenario. So right off the bat, if you recall the prior example, we had just a lot of colors and a lot of text going out to users. So we tried to simplify what that could look like. Now remember, we want to help the reader to read less. And one way of doing that is to focus our attention on what we think might be the most significant issue. So right off the bat, we're trying to wave a big flag at them and say, hey, there are 3 things you got to look at. This other stuff in blue might not be that important right now. In fact, you know, this liquidated damages section is all the way at the bottom, and we just want them to be able to go right to the session and get an understanding. In addition, we tried out a couple of different ways to represent this change. So in addition to the horizontal bar, we have a vertical bar instead of just highlighting everything. So we're going to go back up, and let's just click on this simplifier icon. And so we're just suggesting that there could be a way to pop up the screen and present a very concise summary of what the issue might be, and prompt the user for some kind of action. But like I said, again, we're trying to figure out how to get the user to get to this very critical issue. So let's click on it and see what the fuss is all about. I just want to draw your attention to a couple of things. Here again, we're trying a different way to capture the user's attention by highlighting red, and then also using red text and bolding to really punch out keywords to draw their attention. So in addition, we tried to keep this color scheme of icons to go along with this really colorful simplifier logo. Moving on to the substantive matter, the issue here is really that the counterparty is exerting a significant amount of leverage that could really substantially create an unfair balance in this contract. And so, you know, if I'm a sophisticated user, maybe I understand what that means, but one of the things we want to propose to this light bulb icon is that Simplifier integrates with some kind of legal dictionary online. We picked Westlaw just to strawman this thing out. But we want to figure out how to educate the users if they want that information. So I'll just go back, and here we're back to the main screen, and I could just continue on conducting this legal review. So now I'm at issue 2 of 3. And this is how we envision kind of working at least 2 different levels of contract review in the system on a mobile device. So let me exit out of this. I just want to summarize the demos that we went over. So for the text analysis that John did, we started with a rule set. We really leveraged regular expression matching, and I think we have the possibility of introducing some type of machine learning pipeline to really scale the solution. We went over the user experience and interface. And as for next steps, in terms of deliverables, we're trying to make sure that we package up the general approach for the UX and UI, the repository for the code and our rationale. And then I think most importantly, the lessons learned in research. I think we found out, you know, many different ways how not to approach this problem. And I think that could be a good time savings for the Simplifier client. And so I'll wrap up with Q&A. On behalf of the team, Rodrigo, John, Abhi, and myself, this was the Simplifier team presentation. I want to thank our project sponsor, Rory Unsworth, for support. And if you're interested in trying to negotiate better contracts, check out simplifier.world or go to the source at iaccm.com.
All right, great. Thanks, Simplifier IACCM team. So Khalid, Jason, Farah, and Luke, questions?
I have a comment because, you know, I have a confession to make. Some people on my team a number of years ago worked on a related problem, which is identify abnormalities and deviations in contracts. And we worked on 5 million contracts, 200 million clauses collectively. And the conclusion that we reached at the time is that you can identify differences between a standard clause and sort of Euro clause easily, but to determine whether that deviation is material, whether it's impactful, you are likely going to need to look at larger statistics. So just keep that in mind. I think comparing to one standard is probably not going to give you the materiality aspect of that deviation. But good work otherwise. Thanks.
That was definitely an issue that we ran into, was that there are so many standard clauses out there. There's so many examples, and finding out whether significant change in the context of one clause is a very difficult problem. So this was something we definitely struggled with and spent a lot of time trying to tackle. And it still hasn't been solved yet. It's very complex.
Yeah, it's a difficult issue. It's a difficult problem. Yeah, don't feel about it. Yeah.
So I have a question, as good work. But my question is, there's some already commercially available tools out there that position themselves to do clause analysis. We actually are using one of the ones that are out there. And so I wanted to delve a little deeper and see what I might have missed from the demo. What do you view as your key distinguisher or the thing that makes the secret sauce here, so that somebody wouldn't just want to get one of the off-the-shelf versions of this that are out there right now?
Yeah, this is Justin. It's a great question, and I think it's something we're still struggling with. So, the ICCM is this international organization, and they really feel like they found something very important, where if everyone uses these sets of contracts for contracts that they found to be very, very similar, then people can go into negotiations knowing that the other party isn't kind of getting over on them. So if you can start from this known trusted point, you can quickly go through and agree to the nature of the contract. I think there's a bit of a collective action problem, because in order to get there, you have to kind of ditch everything that your firm worked for, reconfigure everything, and then renegotiate your contracts. And then in addition, in order for it to work, I think many, many people have to come on board. And so I think you're in the case where we are now, where a lot of people would rather prefer to just use something that's tailored to their own organization.
Yeah, well, I can say I think that is a challenge, because that's where we are. For example, we'll have a standard NDA to pick an easy one, and we'll run it through this engine, and it'll identify to us where there are deviations. And for now, that seems to be good enough. So I guess my challenge, my question is, what's next? What are we not thinking of right now that we should be thinking about that would derive value and ROI for us if we were using your tool?
Yeah, I think so. Rodrigo might have some more insight into this, because he's felt the pain of negotiating some crazy contracts. I think a part of the metric that we're trying to figure out is that the ICCM believes, this is their theory, that they can help the world negotiate better. One of the things that Simplify is trying to achieve is to collect data to see if that's actually true. So to collect that data, you need users to go in there and work with the system. So from a benchmark perspective, they just want to reduce the amount of time spent negotiating maybe a simple contract that has taken 6 months down to some time less than that, as one example. And their starting point, and really the kind of thing that makes this project unique, is that they have this curated set of standard clauses that a lot of people recognize to be good. So it's a matter of how do we detect that to both parties that these good clauses are in there and they're both good for both parties.
To build on Farah's question, a way to consider differentiating could possibly be to kind of target your focus towards one of, I think you mentioned like 2 user groups. Generally, there was like lawyers and there was, the average population. Maybe it's, rather than trying to serve both, it could be, go really deep into one and understand, because I imagine their pains and their needs are different. Maybe for lawyers, it's more about speed or efficiency, and for the average person is more about ease of understanding or something like that. Did you find that, or do you believe that one of those 2 groups is kind of less, there's less options for, and then therefore, you could come in and occupy more of a space within one of those certain target segments?
Yeah, so I think we struggled a lot with the question of how do we stay away from alienating a very good lawyer who's trying to use the system. and trying to tell them how to do their job, and versus trying to educate users. So you hit the nail on the head with this problem of trying to serve two very different groups. I think there would be more of an opportunity to probably serve the normal population, so to speak, because there's this kind of access to justice gap. A lot of people don't know what they're looking at. So the example our client put to us is, hey, you know, we have this person, sole proprietor, trying to launch a business. You know, maybe their downstream manufacturer is trying to, you know, take advantage of them. They don't know it. So how do we help these folks negotiate better, you know, in a contract with the opposing side who's got a very high paid lawyer facing them?
If I'm, yeah, just to make an addition here, I understand that this is a very good software for both of them, for lawyers and normal people, because we're not only showing the difference between one version and not the second version of the contract, we're also showing what is the meaning behind this clause. Now, we just use the example of the liquidation damage, and we at the same time we show like the second version, they included this entire section, and also we also showing what does it mean, what is the meaning behind this clause, what is, so you can learn and you can just try to understand what the lawyer is thinking behind all this changing and clauses.
I love how the dichotomy there was a lawyer or a normal person.
As a lawyer can say that.
I can try and attempt to answer your question, Farah. So the distinction that Simplifier is trying to make, because they know that they have already existing competitors out there, and was the way they're trying to delineate themselves from those competitors is by they're currently working on a way to make this way of analyzing contracts more organic for each company. So like, not only are they're speeding up the process and giving or like measuring different stats to see if they're actually optimizing the contract negotiation process, but eventually they want this to be like a recursive process that each company can tailor to their own standards, as well as the IAACM standards. So like they could be like, we value this, or we say this is more significant, and so that the system is self-adjusting. So it's not just, there is a significant change here. It could be, this is what we view as significant, and adjust accordingly. And so, but that's still something that we're currently developing, so.
All right.
Yeah.
Great, thanks, Simplifier IACCM team. Well, we have one presentation left. So the Actuate Law and Allstate team is going to present, and then we'll do the same Q&A. And then before we close, we'll have time for our panel of experts to give some closing remarks about the evening. So the Actuate Law and Allstate team, are you ready to go?
All set. Hey, can you hear us? Hello. I don't know what went wrong there.
I can now.
Oh, sorry about that. I was muted.
All right, there we go.
All right, try again. Here we go.
All right. Hello, everyone, and thank you for joining us. Our product is called Access Buddy. So this is our team. On the CS side, we have Will, KJ, and Elon. And on the legal side, we have myself, I'm Daniel, and Chanchuan. And kind of with one foot in both doors, we have Amanda. So our project partners this semester were Jeff Scherer and Martin Tully from Actuate Law and Megan Pavich from Allstate. So big thanks to all of them. Okay, so the challenge that our product is meant to tackle is related to two laws that were recently passed. So the first of these was the GDPR, which was passed in the European Union, and the second is the CCPA, which was passed in California. So one aspect of both of these laws is that companies have to provide any information that they have about a customer to the customer upon that customer's request. The problem with this is that the way that these companies originally created their data structures, it was not designed to accommodate these requests. So, you know, they might have information about a single person in a variety of different databases spread across different business units. Next slide, please. So very few companies are fully equipped to field these requests in an adequate period of time, and the penalties for failing to do so can be pretty steep. Next slide, please. So based on the presence of these laws, customers now expect that they can get any of the information that a company has about them, and for that information to be delivered quickly, comprehensively, so everything that they have on that customer, and in a clean and readable fashion. So the solution that we have created is called Access Buddy, and it is a tool for both companies and the end customers. And before we jump into the demo, I'll give a brief overview of how the process works. So we have a customer, say Ellen in this case, will submit a request through Access Buddy, and that request will appear on a dashboard that Ray, our request handler, can see. So Ray will verify Ellen's identity, and once her identity is verified, then he will send out a message to the various database administrators maintaining the data for the different business units of the organization, and request the information from them. So once the request is received, the database administrators will dig through all of their data and compile it, and they will then deliver this back to the request handler, Ray, who will then combine everything into a clean format and deliver it to Ellen. So now we'll go ahead and demo the product.
Great, thanks, Danny. So the bottom line, let me make sure can everyone hear me? Great. So the bottom line is people want their data and we give it to them. Companies might have it stored in many different places, and we just want to be the tool to make it really easy to get the data back to the user. We're going to show you what that process looks like. So you're going to go over here, fill out your name, your email, where you live. Great. So your information has now been submitted to our database. And this is what the dashboard, or Ray, the request handler, this is what he sees. So it's going to be an active request panel with everyone's requests that are coming in. And it should also be noted that Access Buddy is meant to be a tool. So Access Buddy is not standing alone. It's actually a tool that websites like, say, Facebook or YouTube could hope to integrate. So a user will actually make a request to YouTube, Facebook, any website of their choice. They would use Access Buddy as the tool to do that. So back to this screen, we have all of the requests that have come in. And if you get details, you can see it's been verified, you get a name, and you have these departments that have to submit things to us. So, you know, if for Ellen, who's made a request, the legal department, marketing, customer relations, they all have information about Ellen. We need to get that to her. So what happens is an email automatically gets sent out. It says, "Dear marketing team, here's the request ID that you need to upload your data to, and here's a link to where you're actually going to be putting your data." So we're going to copy this request ID, and here we put it back, and it takes us back to Access Buddy. Say, "Hey, I'm from the marketing department," and we actually have drag and drop feature. We can collect all of our data and drop it here, not the downloads. And once it's in there, you hit submit. And the zip files that come from each department has to be they have to make sure that they are following the certain protocols and forms that the legal requirement is asking for. So great, now the marketing department has submitted their section. And we can come back to the dashboard, and a completed one looks like the number 12 here. It's green, it's ready to go. So you get details. We have, so the legal, marketing, customer relations is always late. Assume we have their information. All three departments are ready to go. We're ready to send it back to Ellen. It's ready to go. So we send the data, and Ellen, the original user who wanted her data, gets an email that looks like this. It says, hey, Ellen, here's everything, and here's an kind of an architecture of what the file that we sent to her looks like. And it's included here at the bottom. It's called all company data, and it's separated by marketing data, law data, each department. It's already, it's as clean and as organized as we can get it. And we say, here's served from Access Buddy. So again, the whole point of this is to make it very easy for someone to make a request to the company to have a company have a clear understanding of what all the request looks like, gather all of these siloed different places that the company might have for the user back to the centralized dashboard, and give one clean file back to the original user. And this is kind of what we've been working on a little bit, and we certainly have a lot of ideas moving forward of what we'd like to incorporate. But that's where we're at today, and we're excited that you all got to hear us, and this was a great event, and we're opening it up for questions at this point. Thank you.
Okay, thank you, Actuate Law and Allstate team. Let's turn things over to Khaled, Jason, Farah, and Luke for questions.
I'll go.
Go ahead.
Oh, I won't go. Okay, you'll go.
Okay, thanks. So, listen, thank you guys. I think it seems that I don't come across as sort of disagreeing or anything. It seems that you solved half of the problem, providing users with a mechanism to ask for their information. But the other half, enabling the company to reply with these requests, I didn't see it. Yeah, and the fundamental challenge is that it's a question of ambiguity. If someone says, even for a unique name in the US and Canada, like my name, Khalid Al-Kofahi, there are two of us. I have a cousin in Iowa, yeah? So if you imagine a John Smith question, and you have 50,000 hits in your databases, and if you are in the consumer space, your records are very thin. You don't have a lot of metadata for these records. You can't disambiguate, yeah? And this is a real problem for that disambiguation, that concordance is a real problem for companies who are trying to comply with CCPA, for example. And I think that is the fundamental problem that I wish you focus a little bit more on, or at least acknowledge its existence.
That's a really good comment. So it kind of covers two things. One is verifying who the customer is by the request. So hopefully we've got enough information, like their email address, that we are tagging the data that we are storing so that we know, based on their email address and their name, who they are. The way that the law says that you have to verify them is based on the information that you store, but you also have it in your privacy policy. So we'd have to work with the customer to make sure that what they've got in their privacy policy about how a customer could retrieve their data matches the data that we have in our systems to actually be able to give that to them. It is a really hard problem that companies are solving in different ways right now. Some companies, the bigger companies, are able to afford to pay a service to validate that the person who's asking for the data is actually the person in your system. But we know that smaller companies have a problem with being able to verify. So for this point, because our class wasn't long enough to actually solve that problem, we decided to leave that to the customer to determine how they intend to verify and sort of how private this data is. Is it data that can be found online anyway, or is it actually we have, government issued IDs, we have, some really private information. So at this point, it's a per customer basis, trying to figure out how to do the verification process. But really good comment. That is the problem that everybody has.
Thank you so much.
So you've stumbled into a topic that causes me personal agita regularly. So I do have some personal thoughts on this one. In addition to the verification issue, I'm sure you know there are competitors doing this, much like we were commenting before, and in fact we use one of them. So I guess one of the challenges again is to think about, well, what's the differentiator here? What's that ROI that people can't get going from, and I won't give them an advertisement, but there's a behemoth that everybody seems to use these days if you're of a certain size. So that's question number one. But really, I think another question that sprang to mind, and I think we started to touch on this, is it made my skin crawl to think of the idea of sending a request to marketing or HR or some other team and then passing that along to the requester without some intermediary step to ensure that that data is in fact what you want to provide. So in essence, the element of search and review, which is no different than if you were responding to a subpoena or something else requiring that life cycle of data management. So does your process anticipate that there would be an element of that? And is it perhaps something that there wasn't time to showcase in this project, but you would build in so that there's not an instant flip from request to production?
Exactly. Really, two really good points. So to hit the first one first, the idea of other companies are already doing this. Absolutely. And they're doing a great job, but they're charging a crazy amount of money that medium-sized or small companies could never really afford to use. So the goal of this is to be less expensive and have a lot of the same features, but also give them the ability to do exactly like you said for your second part of your question, is to have somebody actually look at the data before it gets sent out. So when Elon was demoing, he showed that we actually have to push a button to send the data, as opposed to it, the last person submits the data, it doesn't go off at that point. The administrator has to go in and actually approve it to be sent. So at that point, they could go and review the data, get rid of anything that they didn't want to actually send, and then go from there.
And a follow-on question before I turn it over to my esteemed co-panelists here. Are you anticipating that part of your expansion plan would be to build in that kind of functionality natively, or would you be looking to do a plug and play through an integration with some other review tool?
That's a really great question. I don't think we have an answer to it yet. We could certainly go either direction, and we could maybe release, within the first release, it would have the ability to do it manually. And then next we would allow integration with other tools. And then finally, we might have something built out ourselves. But at this point, we've not gotten that far.
Well, great stuff.
Thanks.
Jason, Luke, I think we have time for another question if you wanted to jump in.
Well, I'll make an observation, which is really about, it's about pitching generally, and you want to be very careful about framing up who your persona is, because I think early in the demo, I think you mentioned YouTube or one of the larger services. And so then that anchored me on like, oh, so this is like super scale enterprise. And then he took me in a slightly different direction. You want to be very careful, because when you invoke like a YouTube or one of these other services, there's two things that are important to know about them. One, they do all this in-house, but two, they have their own identity store. And so when you're invoking those types of customers, their sensitivities look a little bit different than the SME market, which is, I think, ultimately where you went to. And so I started to kind of get it. But you just want to be very careful about when you are explaining your value prop, making sure that you're like really crisp with that persona, because otherwise, like I start to generate these questions and I'm just like, oh, now I think I get it. The thing that I think you have, so competing on price is always tough, but you actually identified the real pain point, which is, and I think Farrah flagged this, which is, how do I make the process of gating it before it goes out much easier so that humans are not letting the wrong data out, because they will get it wrong every single time. And so that is a germ of like additional risk that is probably hard for the SME market to take in-house, that goes beyond kind of the ticketing capability that you have, that becomes probably very special.
Great comments. Thanks. Totally agree with everything you said. We threw out the name Facebook, I think half in jest, but that's absolutely not our target. And it hasn't been since the conception of this project. So I think we need to tighten that up just a little bit.
Okay, great. Well, thank you to the Actuate All-State team. Thanks for that presentation. We're running a little bit long, but we are also recording this, and we'll be posting this at some point in time. So I do want to make sure that we follow our plan and give our expert panelists an opportunity to provide some general feedback and talk about kind of what they see developing and the importance of the work in this space. And Colin, why don't we start with you? If you'd like to just share a little bit about what you saw and kind of what you see happening in the market and the value of this work.
I have to say, this far exceeded my expectations. I came here with high expectations, knowing you and Kris as well, and sort of your reputation, but this definitely exceeded my expectation. And as someone who have been sort of working in technology for the law for a number of years, as I said earlier, it is very exciting to see sort of computer scientists and attorneys and sort of creative designers put their heads together to solve these problems. I think the common thread that I saw is that everyone is trying to solve a real problem that is meaningful, that has significant demand. Some of these problems will, improve access to justice. Others will solve sort of real problems that exist in society, and so forth. But overall, I think the amount of work that was done in a class project in a quarter, and what the teams were able to achieve significantly exceed my expectations. I think there are a couple of projects that I think are more achievable than others, given certainly the scope. For example, the order of protection or the Stark law violation or review. These are more, I think, more achievable than the flashcard generator. As much as I like that idea, I think it's harder than what it seems to be, at least on a first cut. I yield the rest of my time. Thank you, guys.
Thank you, Colin. Jason.
Unmute myself. So fabulous creativity on display. I think there are just really good things that happen when people like me, who are loaded with baggage and apparently live to kill people's dreams, don't get in the way of creating really cool experiences. And so I would say creating products and experiences is just a journey, and seeing how far each team progressed in such a short period of time is really just kind of amazing. And I really want to accentuate the power of your storytelling, because you had something to show. It is so much more powerful when you come with something that's like, here, I made this, I'm going to kind of step you through what it feels like and what the experience is. And it really just kind of, you can see us light up and go like, ooh, that's interesting. And oh, what else could we add? And so whenever you have people stepping into your experience and saying, yes, and I also want this, that is a really, really good sign. So one thing that I saw on display that I thought was mature beyond any expectation I had was, your deeper understanding of going into who the customer is, what their job to be done is, their context, including upstream and downstream, and their available resources. So when you're thinking about really like what you're producing, whenever it's touching an end user, that experience is your opportunity to differentiate. And I saw so many things today that ultimately create, I think, some really fabulous potential customer experiences that can be truly, truly differentiating. And so that was just magical to see. The one meta thing that I kind of walk away with is how much creativity beyond what we saw today could we have unlocked if there were better data available to you, especially in like the public record space where like what could we do if we did that? And so there was a comment that I found very powerful, which is, you know, at the state level, it really depends on basically who the agency head is, like that steers the amount of investment that will come from the data sources. But one of the things that I take away from this is you basically created a business case for investment by public agencies to do that, because if they made those investments, what would you have produced for them for free in many of these scenarios today that could be creating real value for their constituents right now? But I just want to say thank you, because I walk away from this very energized, and I think it was Luke who said like the future is going to be very bright. So thank you for putting some wind in my sails, because this was fabulous.
Great, thank you, Jason. Farah?
So, you know, my very eloquent co-panelists, you know, said a lot of things that I agree with. So I'll sum it up as follows. You guys rock. This was awesome. I too feel very energized, and as I hoped at the beginning, inspired. I'm ready to pull a Rodney Dangerfield and go back to school and join Dan's class. I mean, there was nothing like this back in the day. So I think it's such a privilege for me to be a part of this dialogue that you're having. And I hope each of you feel like it's a privilege to be part of this journey that the whole profession is going on right now. So thank you for inviting me to be a part of it. And I'll echo what Jason said. When we, you know, sort of throw these questions at you and want to dive deeper and ask for more features, that means we're engaged. So that's a really good sign. You want us trying to poke those holes and take you to that next level. So I hope everyone received that feedback in that spirit. So thanks again for having me.
Great. Thank you, Farah. Luke?
Yeah, well, I'll just say, first off, thanks again for having me involved in this. 10 years ago when I was getting my MBA at Kellogg, I remember being in the shoes of the students here and how challenging it can be to go from, you know, having very little knowledge of an area to then having to come up with a product idea that's solving a real pain point and need. And I just thought everyone I saw did an excellent job, both in the ideas, but also the presentations. And another thing I wanted to add is, so one of the things that we do at Chicago Innovation is something called the Chicago Innovation Awards. And I just want to give a quick shout out to Kris Hammond, because he's won 2 of those, which is 2 more than most people. But the reason why I mention that is because, you know, every year we get about 500 nominations or so. And I would say 10 years ago, maybe it's a couple or a few that are in the legal tech space, but it's just been like a hockey stick, you know, even in the last 5 years. So I would say, you know, the legal industry really is ripe for innovation. Now there's an opportunity and a challenge related to that. The challenge is that it is often a conservative world with, you know, risk aversity, especially when people who are making the decisions maybe are, you know, they've been doing it the same way they have for 30 plus years and they're comfortable with that. So that's the challenge, but it also is a massive, massive opportunity. And you look at companies even locally, like Relativity is a good example. They're up to about 1,000 employees or so. There's so much opportunity right now in Chicago in the legal tech space. And just seeing these presentations clearly to me indicates that there's going to be a lot more to come. So I hope that you continue down this journey of combining entrepreneurship and the law together, because it's a very exciting one at the moment.
Great. Well, thank you, Luke. I want to give my colleague, Kris Hammond, a chance to say some words too at the close here. First, I want to again just thank our panelists, Khalid, Jason, Farah, and Luke. You did a wonderful job. Thank you for spending so much time with us and really digging into these projects. It's really great to have your participation and collaboration. And again, I want to just thank the project partners, right? Because this also wouldn't have been possible without the people that they devoted and their collaboration and partnership with us. And thank you so much to them. And our students, I mean, we just had some amazing students. You saw them on display this evening, and to have this interdisciplinary class and to have computer science students and law students come together and work in these interdisciplinary teams, learn a little bit about Agile Scrum and product development, and work closely with their project partners was really great to be a part of. And I'm really privileged to be able to work with Kris here and for the things we have going on at Northwestern. I mean, this real partnership between computer science and the law school and the many faculty and administrators and our deans, Dean Julio Tino and Dean Kimberly Uracco, that support this program. So really also energized about all we have going on here. And Kris, I wanted to give you a chance just to give a couple of remarks here.
I don't have a ton to say except one, thanks for the panelists. Thanks for being here with us. Thanks for your comments, and thanks for taking it in. That is that it's not. It's clear that you are open to listening and open to understanding what the students are doing here and what they're striving for. But I think for most of all, I just want to say I'm incredibly proud of the students who did this work. These are kids. These are students who are coming at this from two incredibly different cultures. That is, in the law, the world is bespoke, and in computer science, bespoke is an anathema. I mean, all we want to do is build things that are repeated 1,000 times, 10,000 times, 1 million times over. And getting those cultures together and getting people to understand what it means to take a piece of thinking and try to move it into scale is challenging. And in fact, from the computer science side, understanding what it is that the law is trying to do is incredibly challenging. And I think these teams did an exceptional job, and I'm super proud of them. And I have a tiny little bit of extra pride I have for the computer science students. That is that CS we're on a quarter system, and the law school's on a semester system. So the computer science students got their grades 2 weeks ago. But they're here, and they're here not because they're being professional and they're being responsible. They're here because, in fact, they love their work and they loved working with the teams that they were connected to. And so I think this is, I think this class is actually emblematic of what we want at Northwestern and we want computer science to be. That is outward facing, connected to the world, connected to the work, a part of the driver for change. And that's it. That's all I got. I've seen these students give these talks and these presentations and talk about this work a dozen times. And every single time there's something new, and every single time it's exciting. Every single time it's energizing. Every single time they are inspirational. And I appreciate that. So that's me.
Thank you again to everyone, the experts tonight, the project partners, the students, and thank you for so many people who tuned in. We had well over 200 people at many times tonight, and many other people who went through. Many of you are part of our Law and Technology Initiative and have been in live in-person events here in Chicago. We look forward to seeing you in person and continuing to build this community. We're going to be doing more events online. You're now on our email list, and we'll share those events that we're doing. And we welcome you to collaborate with us. We want to do more projects like this and in more classes and outside of classes and get our students and faculty working on projects. So thank you so much, everyone. I'm very proud of what the students did in this class. Also really proud of this community and people coming together and supporting all this work. So thank you, everyone. Everyone stay safe, stay healthy, and we look forward to continuing to work with you and collaborate in the future. So take care, everyone. We'll get the video posted, and hopefully you can tell others that they should take a look at the video and see some of the great work that our students with our project partners. So take care and good night, everyone.
Good night. Stay safe.
Bye.
Bye. Thank you.
Thank you, everyone.